discussion number 4, the topic of which is data. It's here, it's there, it's everywhere. Navigating global data sharing regulations and standards. The moderator of this discussion is Ms. Tejal, Patil, General Counsel, Wipro, and we welcome her with a big hand. Ladies and gentlemen, please help me welcome the moderator of the next session. And now we also welcome the panelists of this discussion, Mr. G.V. Anand Bhushan, founder, partner, Bhushan, Rajaram. And the applause continues. Why won't you help me, ladies and gentlemen? Thank you so much. Next panelist, Ms. Shalini, Saxena, Head of Legal, CoinDCX. Mr. Rishi, Anand, Partner, DSK Legal. Ms. Lakshika Joshi, Associate GC, Capgemini, Americas and Lead IP Counsel, Global Capgemini Engineering. Mr. Ashish, Chandra, General Counsel, CoinSwitch, Kuber. And Mr. Vineet, Group General Counsel, Tech Mahindra. And once again, we offer a warm round of welcoming applause to all our panelists. And the moderator, Ms. Tejal Patil, will now be taking over.
Good afternoon, everyone. Post-lunch sessions are never easy, but this is a topic that I would say, in some sense, has on one level been beaten to death. On the other hand, it is moving and changing so fast that it's ever new. So let's start really by jumping into a couple of things. One is really what we've seen is, the 2 years of the pandemic, and the digitization has really accelerated the interconnectedness of the world, right? There is data, and this topic is so sort of well created in the title of here, there, and everywhere, right? Because what we saw years ago was, I remember the GDPR, and that itself was a huge change that was being brought about in the world. And since then, the plethora of legislations that we have seen is unbelievable. Given this current pace of technological advances and innovation, it is important for companies to understand the security safeguards and regulations in place to protect their privacy and data. It's also important for companies to be mindful of relevant legislation and regulations on the horizon to address these data challenges facing business operations everywhere. So what we've decided to do today is focus a little bit of our discussion on the actual law and talk about what is happening across the world. So we will start really with the global landscape, and Anand, we'll start with you. We've got a couple of law firms on our panel, so we'll start with them giving us a real view of the legislation. See, we heard about the EU, we've heard about the US. Now, almost 2/3 of the countries in the world have a data privacy legislation in the works, either passed or in the works, including what I've recently read is even Indonesia is now thinking of passing their data protection law. So what I'd really like to understand is each country's approach to these laws common? Do they have different considerations? I mean, why don't we just come out with one code? It just looks different in every country. Or are these codes really different from each other?
Thank you. So this is a question that is easy to ask and hard to answer in a short time. And I should appreciate the effort you took before the panel. She took a lot of effort to make sure she would ask pointed questions and ask us to provide clear answers to the point. So I'll hope to live up to that description. It's a talked about topic, right? Data privacy, the multiple countries' legislations and all of that. It's being over-engineered. So is there a certain commonality? That was the first question. Great, 120 countries have data privacy laws. Great. Is there a commonality in it? The answer is yes. Almost all countries' regimes will have 4 key criteria. What are those four elements of a privacy piece of legislation? Number 1, there will be a notice requirement, which is where half the lawyers in this room have drafted privacy policies and all of that. So that's the notice, how I'm collecting your data. The number 2 is the consent element. Do I give my consent for you to process my data? So it's very simple. Almost many areas of law is you have offer and acceptance. Here it is notice and consent. And then comes the last 2 elements. That's relating to access controls, meaning are you collecting it for its intended purpose? Are the right people having access to that data? And we come to the 4th and final common element, and this is where there is massive digression among all the countries. Okay, the 4th element is enforcement, right? A lot of countries rush to pass laws, or they amend existing laws. What's a good example of that? India, right? Our data privacy bill, now data protection bill. You know, we've less said about that, the better. But we amended the Information Technology Act, snuck in a few privacy provisions, and we don't even have a data protection authority, what, a decade later, right? Nothing's moved on the ground. So that 4th element, right? So to just summarize, the notice, the consent, the access controls, and the enforcement piece. The enforcement piece is where a large parts of countries' legislations unravel. So you have a gold standard, which is the GDPR regime, right? It covers a lot of Europe. You know, why did I say a lot of Europe? Like, for example, post-Brexit, UK has its own data protection 2018 Act, which is plugging the loopholes. So while you have these common elements, keep in mind that the enforcement mechanism is non-existent or weak in large parts of the world. So to answer the last part of your question, right? Great, this is the landscape. Give specific examples of how the landscape is. I'll just cover 3 to 4 countries, all right? The biggest country obviously is North America, United States of America. And they've largely left it to commercial contracting. They said, let businesses do what you do best, and for the longest time left it to private parties and private corporations to find their own balance. Obviously that did not work post-GDPR regime, but even then, there's no federal legislation. You'll have, say, a state like California using the Consumer Protection Act to have a very progressive, forward-looking piece of legislation. So if you would say, what is the United States approach? Despite GDPR, despite so many of the international treaties unraveling, and that's one of the topics here, they've gone state-wise, which I think complicates things tremendously for people seeking to do business there. Another example is Canada with Pipeda. They've just, I don't want to say cut and paste, but incorporated large parts of the GDPR, and it's a national legislation, easy to operate, it translates very well with GDPR, and that's a great example. Perhaps not the best example is India, right? The legislators have gone kicking and screaming because of the pressure of a Supreme Court judgment, which gave recognition to privacy laws as a fundamental right. Otherwise, the Indian government was going in a different direction, right? If it was for a state purpose, if it was for a public good, it didn't matter if it was Aadhaar, if it was your personal identifiable information, if it gave benefits to the public, if it helped curtail corruption, if it enhanced banking, why not? And I will end this session with that contrast, right? I think the biggest and the most important part for India to keep in mind is, you know, everything West is not always the best. So we should not get caught in a zero-sum game of there should be absolute privacy protections and the data subjects must be absolutely protected. So we know nothing at all is required. So we have to strike a balance. And that balance is so important from an Indian perspective, especially with the there's a running joke, okay, any lawyer you ask for the 4 years, when is our Protection Act? 4 years, they say in 6 months, winter session of Parliament. Again, the government has put one press release, winter session of Parliament, it's coming. But I hope, you know, we strike a balance, especially when it's coming to unbanked populations, how we use Aadhaar card, how we use personal identifiable information for banking, for direct benefits, for subsidies reaching the intended recipient. We need to tweak the Indian formula, especially when it comes to the states, for the benefit of its citizens. And I just wanted that social good as we focus a lot on commercial enterprise as well here.
So Rishi, why don't you kind of jump in here? So we debated this law, like, Anand spoke about it in India for 4 years. So what was wrong with it? And what is it that they will do now that we hope, will bring a clearer and a more enforceable legislation?
Thank you, Tejal. I think Anand has given a very good background of how the law evolved internationally. And how the law in India evolved was basis probably what was happening internationally. And as we all know that law follows businesses. So with the big tech coming into the picture, data became really important and as good as gold. So everybody was behind that. And for us, data protection bill came in 2019. We billed for 2 years, and then it was scrapped. So again, and the new bill is coming in. And the primary reason where it all started was the Bhushan judgment, which actually recognized, data privacy as a fundamental right. So we will see the development over a period of time, but the last bill saw so many amendments, and while dealing with the stakeholders and the government, we realized that the bill, which was in its form, was not catering to the needs of the industry, nor was actually providing all that was required to protect the interests of the common man. And that's where the social angle comes, and that's where the government had its own reservations, and the reason why probably it was all scrapped after the 81 amendments and suggestions. Hopefully, the way forward, one of the major reasons again, which was raised by the big tech companies, was the bill in its existing form was quite onerous and draconian from the big tech companies, while it was not restricting the central agencies to actually have an embargo on them. So that was one of the major reasons and setbacks that we see from the industry, which we saw from the industry perspective, while people from the industry provided comments and suggestions to the government. So going forward, I feel that as the technology is evolving, the new law probably should see the light of the day soon. And as pointed by Anand, in the winter session, they have already said that they will present the bill. So let's hope that we have a better law and we will be in a better position to deal with the issues coming out.
Shalini, any comments on legislative developments?
I think between Anand and Rishi, they covered it. We are going to find the new oil and it's going to see the light of the day. As a business, I think for anybody looking at data privacy across the globe, it's a nightmare. Trying to match or catch up or comply with everything that looks different. Which is why I agree with what Anand said. There needs to be a baseline. Set something that works for consumer as an individual right, works for national security, and lastly works for cross-border companies doing businesses. Set that and then you can flesh it out for everybody.
So great segue to Lakshika actually, because of cross-border, right? When you look at multinational companies or companies that are servicing now across the world, what do you make of these laws, which are really first of all starting with their local sovereignty? Every government is trying to protect the data of their own citizens, and as we sort of see this, national security concerns, commercial concerns, just gathering intelligence on everything that you possibly can. Governments are seeking to maintain digital sovereignty and control through protectionist data localization mandates. Right? We've seen the Schrems II judgment in Europe, which has actually changed the entire landscape of how data transfers take place outside of the EU. So, in your role and in the context of industries that operate across the world, what do you see? How do you navigate it, and how do you even understand? Because
we make the first mistake, I think. For us to just keep it very simple and to the point, I would say data sovereignty is nothing but controlling or rather let's say regulating the data in the jurisdiction where it is created or collected, and now the governments are beginning to realize, or regulators are trying to sort of see if they can make rules, guidelines and laws to do various things with it, and those various things could be their data protection laws, it could be their data protection law could have data localization conditions, it could have many others, but it all sort of then falls in the bigger basket of data sovereignty and how that needs to be maintained. So data sort of moves on its own, like you said, it is everywhere, and we need to almost sort of see it like an entity which needs to be then sort of governed by the laws where it is generated. And that's what all of the governments across the globe are trying to do. Now, with that, we've seen how, GDPR, we mentioned earlier, is the gold standard, but we've seen that that in itself has gone through changes and improvisations. With Schrems 1 and then 2, we see that the whole landscape is evolving. With Schrems 2, so there were the SCCs, the standard clauses, that you could have, the standard contractual clauses, which got sort of revamped with Schrems 2. We still have some companies sort of catching up with that. We're still trying to, so if I can sort of get into what Schrems 2 was, it sort of invalidated the privacy shield that was recognized earlier between US and EU, and therefore there is no free transfer of data in the transatlantic zone. But if you look at it, this directly hits the approximate $900 billion of commerce that actually happens in that zone. And to be able to sort of avoid that, it is only logical that governments would come together, try to channelize it and bring together methods to overcome this. So I think in 2 years of consultations, which started in 2019 till about March 2022, which is this year, the EU and US has now come up with a framework, which is called the Transatlantic Privacy Framework, whereby they would have a framework of how data can move between EU and the US. And I'm focusing primarily on the US because US itself, we are seeing, is at the same time in the last couple of years has come up with many state data protection laws. There are 5 and it's counting. So US for the first time ever has started to recognize the data subject rights now. Even in California, they always had the Consumer Protection Act, but they're sort of amending that with adding on a Consumer Privacy Act to it, which will be effective from January next year, 2023. So this is the rigor with which the transatlantic zone is trying to address it. Now, what happens thereafter is that the Schrems 2 also sort of gave guidelines that the standard contractual clauses will need to be amended or improvised. And these clauses, the new clauses that are improvised, we need to keep in mind 2 very important dates. These became effective last year, which was 2021, but companies still have time till end of this year, which is December 27, 2022, to actually become compliant with the new contractual clauses. Which means that if there are old contracts, old MSAs, SOWs that they are continuing to work under, they can continue to do so till such time there isn't any new project which requires some new data processing. For that, they will have to still adhere to the new SCCs and sign off new SCCs. However, if there's no new project or no new data processing, they can work on the old contracts till the end of the year. That is date 1. The other thing is that with the new SECs, a lot of provisions which were not present in the earlier old SECs have been added on. So you have provisions where you can incorporate specific sections and terms without having to sign on new SECs altogether. And you can just incorporate into your existing contracts. You have the provisions to latch on to the mothership. There are the blocking provisions where If there are new entities added to your group through acquisitions, you don't have to revamp or sort of the whole process and sign off new SECs, but you can add new entities and so on and so forth. Now with corporates such as ours working across the globe, another concept of PCRs is what sort of we leverage upon a lot. And we are very stringent with that because PCRs is what actually guides our transfer of data from countries to countries. And it's not only about data that we control. So even with the new SECs, there are 4 modules. There are modules for controller to controller, controller to processor, processor to processor, and processor to controller data transfers. But the PCRs always cover these processing requirements as well. So whether you were a controller or you were a processor of the data, the PCRs were sort of your safe haven. So I think that's what any ethical multinational company would do and have been doing for a while. Of course, if there are changes or amendments required to that, then companies will do that. The advantage with PCRs is that sorry, Anand, I get that sort. No. I don't want to overrun the time. So I'm not listening to that. So the advantage with PCRs is that they are approved by the regulators, and therefore they're also considered the gold standards when you do any kind of data transfers across the globe.
With that, I am going to do the follow-up to Anand, which is one of the interesting things that you said was, Europe and US are trying to figure out their own mechanism, the 2.0 version of how they will transfer data between these two blocks. So Anand, do you think, given sort of the world developments we're looking at, that these are going to become bilateral in nature? I mean, this is going to be like our, data versions of FTAs, where certain places become safe havens?
That's a very, very perceptive analogy, right? I just want to address the elephant in the room. The reason why the Privacy Shield failed was because of their national security concerns. For the Patriot Act, for undisclosed reasons, they were able to process. The United States government was able to process data, and the Europeans said, tough luck. We don't feel it's maintaining the adequate privacy standards that is required for our European data subjects. That's the elephant in the room. That's the problem statement. I don't see that problem statement going away for countries like India, for China, for Russia, and quite frankly for the United States of America as well. So how are you going to get around it, right? You're either going to have these bilateral treaties, which is how FTAs have gone. WTO, when was the last large reform there? It's all gone individual rounds. Two things will happen. Either the bilateral problems get solved, or the internet will start to fracture, and that's going to be an alarming trend of what you're seeing in deglobalization, right? So every country, believe it or not, is talking about their version of Hindi is terrible, this Atmanirbhar, I don't know, I'm pronouncing it terrible, but this self-reliance, right? This mindset of my border, my territory, my data, my processing rules is going to drive a lot of the deglobalization discourse, which will impact data. And a siloed internet, and it's not too far-fetched, right? You use your Netflix in the US, and you use your Netflix, it's already happening. Content is anyway being siloed, and that's some of the most interesting data out there, right? So.
I was just going to add to that, perhaps that's what they're trying to address to the transatlantic framework agreement, that they're trying to still sort of work through. Because it has two aspects to it. One is how the US would have access, or US agencies will have access to data which resides outside US. And the second part, which also is very important, there's not much talked about, is where I'm interested to see how it evolves, is where other countries will have access to data from servers that are based in US or that resides in companies that are in the US. So there are two parts to it. Of course, a lot has been talked about. There have been white papers on part one. We are yet to see how the second part goes out. And that will be important to see how this whole bilateral thing will function.
Vineet, you wanted to jump in on this question.
I'd like to add, it's not a different perspective, but I think it's the overreach which is a problem. The state's overreach, which is a problem, and I think that's probably the issue of dismantling of this American shield, and so on. So I think we face this problem in India also, and you could call it a ED or whatever, a law in itself. But as long as you have this fear, and especially when you talk of companies transfer of data into different jurisdictions, I think one is about the act and the legislation. So that's very important. There is no question about that. But how is the how are the corporations in those countries handling that piece? How maturely do they act? How good is the assessment, audit, systems, tools and processes there as a corporation? So, I was just doing a little Google this morning, and what I see is 2.5 quintillion, which is what? Million to the power 5 bytes of data is getting generated on a daily basis. They say you could travel to moon, if you put it one after the other, you could travel to the moon and come back. 500,000, Snapchats, if I'm doing that, coming every minute. Google search is about what, 3 billion searches a day. So that's generating data in its own way. So and a cartoon that I saw this morning was, how do we solve this data protection problem? Is it that we negotiate? Do we have laws? Or the last was, why do we need this so much of data? We're just collecting garbage data. So it's a lot of debate. And how do we handle this is the second part of it. But maybe from a corporation's perspective, and that's something that is close to me also. How do you build in a system as a corporation? How you handle data properly, securely? And corporations today handle data, of all kinds, vendors, employees, partners, and so on and so forth. And for processing purposes, it really moves to different jurisdictions. Anand, you just talked about laws in various places. Another example is Philippines. They've had their, data protection law in 2012, and it's a great place for BPO and other businesses. So it's done well. They have their national judicial, some national commission on data protection. You have these new laws which have come up in South Africa, in UAE, and so on and so forth. Some implemented, subject getting implemented. DPO is a requirement. So I think it's all about building the tools, processes, systems, and of course the other part of it, which is corporation taking care from data privacy, putting into place trainings and so on and so forth. So I think it's a combination, and the Data Protection Act itself may not just solve the problem. Just wanted to add that piece.
And that's really important, because I think one part of it is, what you are talking about is what we can do as companies intersay when data transfers. When we collect data, when we transfer data, etc. The other piece, of course, is when we look at just data breaches, right? I don't think you can today look at data protection and data privacy without looking at the cybersecurity part of it, because this is inherently a leak in the system. There's as many protections as you build in, there are that many people who are out there day in and day out trying to figure out how to break that system and how to get at that all-important gold or oil that is the data today. So any thoughts just to add on there, and then I'll pass it to Rishi to add to it.
Yeah, and maybe not just oil. I think we have these 5 tattvas, earth, air, water. So it's not just oil. I think it's data now, for sure. But yes, I think the thoughts as a corporation I can talk about, and I will kind of repeat, is the fact that we also kind of confuse between these data privacy officers or data protection officers, as we call them sometimes. So there is a DPO, there is a CIO, there is a CPO, and so on and so forth, and who have different roles to play, to my mind. So I think how do you strengthen your departments? How do you strengthen the teams is one part of it. So you equip them with tools and technologies, which you need to take in, which is bread and butter for a lot of corporations. But then you keep updating and upgrading. So that's one part of it. The second part is assessment, as we said, and from a GDPR perspective, you have these PIAs, the the privacy assessments that you kind of do. The customers insist that you do that. So that's the second piece. You maintain the records of processing, so ROPs also follow. And SCCs that Lakshika just mentioned, and these DTAs that you kind of enter into, deal with processor with sub-processors and controllers with processors, or between the the intercompanies also. So you need to put a framework into place. So that's the second piece. And third is about training. How do you kind of train your staff? How do you ensure that there are appropriate policies around, say for example, passwords and so on. So some very basic things. So I think it's a gambit of attack that you need to make. There is no straight answers. There is no full solution there. So that's my.
So I'm going to skip the follow-ups because I've been told that we're running. We're really running out of time. We're a little bit running out of time. So I'll just go. We've got a couple of people on this panel. Shalini already spoke, but a little bit around the whole crypto world. So one of the things, Ashish, really is, the recent journey from end-to-end encryption to cryptographic tokens, right? It's the classic balance between free speech, free business, and balancing that with the national security interest. How do you share your experience from sort of your world as to how this plans out for you?
Yeah, so the only way to enforce the data protection of privacy is through cryptography, because that's the technical standard to enforce the data privacy or protection whenever the data is in travel, right? So I think end-to-end encryption, like my last job in WhatsApp and all, and it's not only about WhatsApp, it's about all communication app, whether it's Signal, Telegram. I think they give you an element of safety and comfort whenever you are chatting or communicating with your loved one, like in any bedroom or in any living room. But I think there is always a legitimate expectation of the government to have some sort of a control in terms of somebody misusing this technology to have private communication which would go against the national interest. And it is not only something that the government want, it is also enshrined in the Buddha Swami judgment. The only exception he built into, or that judgment built into, was for national security, right? Now I think, how do we implement it, right? It's like sometimes through technology, let's say cryptographic tokens, right? So cryptographic tokens are not for the communication, but it is for the means of payment, the means of exchange of some value, right? So the baseline technology there is also cryptography, right? Now, the challenge between the technology and the law, it's not that you can do it partially. For example, when we talk about end-to-end encryption, there's nothing in the hand of the communication app which could decrypt it, because it's being, if I am sending you hello as a chat or as a message from my, let's say, WhatsApp to your WhatsApp, from my Signal to your Signal, these companies don't have any ability to decrypt it, because I am encrypting it from my private key in my phone. You are decrypting it with your private key in your phone. Now, how do you decrypt it? It's like technically impossible. Therefore, India is not taking some sort of very concrete step in framing the encryption rules. India is not taking steps to enforcing the existing Section 69A or B of IT Act to ask all these intermediaries to decrypt it. Although they have recently built in the element of traceability, so to say, under the information technology rules, but we all know that this has not been enforced. Because if you enforce, you kill technology, right? You cannot have a balancing act. Now the important part is that, and I'll end over here, is that जो पुलिस हमेशा चोर के पीछे भागती है, चोर हमेशा आगे भाग रहा होता है, ठीक है? So police has to also upgrade its skills so that they can defeat the thief who is running ahead. The question which we need to ask ourselves at the government, how much are they investing in upgrading their capability to solve all these problems imposed by end-to-end encrypted apps or cryptographic tokens, which could be money laundering issue, which could be terror financing issue, which could be hiding of income. These are being solved in wild west. I know Anand said that may not be the right example from the Indian context, but we need to learn a lot from them. These people embrace all these technologies for public good. But in parallel, they also upgrade their own infrastructure, the capability of law enforcement and regulators, judges, public prosecutors, right? They all have to upgrade. Now technology आपकी आगे भाग रही है, मूल पहुंच गई है और आप अभी तक you are in some case, right? So that will not very. That's why India is behind the IT development. We are IT consumers, but we cannot. So national interest important, but the nation should invest rather than kill technology. They should invest to build alternate technologies to safeguard the misuse of good technologies.
So on that note, I'm going to do one quick question across for everyone, and then we will conclude because this is a huge topic in itself. I think we could do days on it. On a scale of 1:10, and we'll go right down the room, where do you think India Inc. is in their readiness to data protection?
I would say 2. It's like that Snow White's mirror on the wall. Depending on who asks that question, they say your privacy policy is the fairest of them all.
About 2, 3.
1. Not ready at all.
Mixed, it's surely less than 5, but it depends. If you're talking to corporates, you're talking to government, you're talking to enforcement agencies, different levels. So,
I think India Inc. 10 out of 10, but Indian government 0 out of 10. Recorded conversation. It's not encrypted.
No, I think it's high. It's anywhere between 6 to 8.
So on that sort of happy conclusion, it's like the great Indian wedding. When the law happens, we will be ready. Right. Thank you, everyone. Thank you.